Hi, Misha Gill with Speedwell Law. Today I'm going to talk about transfer on death deeds. Transfer on death deeds are great. It's great that we have them in Virginia. Many states do not have transfer on death deeds, so the fact that we have them is a privilege. Transfer on death deeds, the best way to think of a transfer on death deed is as a beneficiary designation for real estate. And that means that you are designating who is going to receive the real property on your death. Now, there's a couple things to watch out for with transfer on death deeds. They're revocable, right? So they can be revoked. You can make changes to them during your lifetime. And the way you would do that is you would send a revocation document to the same place that the deed has been recorded. And that's actually the most crucial thing with transfer on death deeds is that they get recorded. If you create a transfer on death deed, sign it, notarize it, and then fail to record it, it's not effective. So you got to record the transfer on death deed. Some other things to watch out for with transfer on death deeds is that they're a little more brittle than a will. The will plans for more scenarios. It plans for who might take after the named beneficiary, for instance, an heirs at law designation. You can do a little bit of that with a transfer on death deed. The transfer on death deed in Virginia allows you to say what happens to the property interest on the death of the beneficiary. You can say that it shall become null and void, or that it will pass to their issue. That means to their kids. And so that might be a good way to do a little bit of estate planning with a transfer on death deed. The transfer on death deed is nice and affordable. It just carries with it about the same cost as preparing a deed for real property conveyances. You can pull a statutory transfer on death deed off the internet, off the Virginia Code, even if you're good with word processor, and thereby figure out how to convey your real property to the intended beneficiary without the necessity of probate. And so that makes them a good, affordable, cost-effective way to do estate planning for your real property. However, there are a few formalities and they are a little brittle, so you definitely do need to pay attention to them. And if you have any questions, please don't hesitate to reach out to Speedwell Law.
Why might someone do a transfer on death deed instead of just a will or just a trust?
Well, a transfer on death deed can be a good part of a plan that is meant to pass by beneficiary designation. So you can establish a plan that transfers your property, real and personal, to your intended beneficiary at your death without using a will or without using a trust even. And so a transfer on death deed would accomplish that if it's also part of a pay on death, transfer on death, beneficiary designation type plan. So it can be very convenient in that way.
How often do you prepare transfer on death deeds?
You know, actually not all that often, because transfer on death deeds, they are effective, but a will does the same thing, but better, right? So in Virginia, a will also transfer real property interests at death and take the same function as a transfer on death deed without the necessity of probate, because we have in Virginia this concept where title to property drops like a rock onto the beneficiary, the legal heir. If you establish your legal heir in your will, then you can transfer your real property to that beneficiary using the will without the necessity of qualification. And so if you pay on death, transfer on death, beneficiary designate the rest of your estate, and create a will, and the will takes care of the real property, transferring it to the intended beneficiary at your death, then you don't also need to prepare a transfer on death deed. The will takes care of it.
Why might I use a trust?
So you might use a trust instead of a will or transfer on death deed for a couple of reasons. Primarily because a living trust keeps things private. You don't have to furnish anything to the court, and you can take care of the job of conveying the asset during your lifetime. So a living trust is a document that you can convey, well, it's actually a contract where you can convey property to the trustee during your lifetime. Revocable, inter vivos living trust. Inter vivos means during lifetime. So you would convey real property to your living trust during your lifetime in order to effectuate the title change right away, and so that then the trustee can automatically take control of the asset when you pass away, and without the necessity of filing anything with the probate court.